Prime Minister accused of misleading the Queen and undermining Parliament. It's all ended up here, at the highest court in the land. Two contradictory rulings are being appealed. One from the Scottish courts, which ruled that the Prime Minister's advice to the Queen to prorogue or suspend Parliament for 5 weeks was unlawful. And one from the High Court in London, which ruled that the entire matter, the proroguing of Parliament, was political and not a matter for the courts at all. It's not really like the kind of criminal court you see in TV dramas. There are no witnesses, juries or cross-examination. It's all a bit more like an academic seminar with brilliant lawyers arguing points of law in front of some of the best legal minds in the country. There are 12 justices, but they normally sit here in panels of 5, 7, 9. But for this case, on the suspension of Parliament, for only the second time ever, they're sitting as 11, so that no one can say, well, if there'd been a different panel, it would have been a different result. The Prime Minister said the suspension of Parliament was needed to prepare a Queen's speech setting out a new government agenda. The businesswoman Gina Miller argues it was to silence Parliament during critical weeks in the lead-up to Brexit. This is where the government lawyers appealing the decision from the Scottish courts will seek to persuade the justices that the proroguing of Parliament is really a matter of politics and not one for the court to interfere with at all. At the end of this case, the justices sitting here will give a definitive ruling on whether the advice given by the Prime Minister to the Queen to suspend Parliament for 5 weeks was unlawful or not. And that will determine whether Parliament can sit again in the days leading up to the 14th of October, when the suspension was due to be lifted, and during that period, therefore, whether they can legislate and consider Brexit issues.